everyone, and welcome back to Insured Success, the Reed Smith Insurance Recovery Group podcast. I'm Khalid Knox, an associate out of Reed Smith's Los Angeles office. Today, I'm joined by two very special guests, Carolyn Rosenberg, a partner out of Reed Smith's Chicago office with a national and multinational practice, and David Garrigus, an executive VP and North American practice leader for professional and executive risk insurance at Hub International. It's great to have you both here. Today's topic is prediction markets, and specifically what their rapid growth means from an insurance perspective. We plan to touch on claims handling, coverage, and underwriting. To set the stage, prediction markets are exchanges on which participants can buy or sell contracts based on the outcome of future events. These event contracts are listed on Designated Contract Markets, or DCM for short, which is a platform federally regulated by the Commodities Future Trading Commission, although there has been some recent disputes on that point, which we may get into a bit later. These event contracts and prediction markets allow participants to trade on everything from election outcomes and sports wagering to corporate earnings. Prediction markets are a very hot topic, both from a financial standpoint, where trading volume has grown from roughly 1 billion to more than 20 billion in just 5 years, and in the news. We have seen breaking headlines such as a U.S. soldier charged with using classified information to profit from prediction market trading. Governors of New York, Illinois, and California, for example, signing executive orders barring state employees from using non-public information to trade on prediction markets. And several state attorneys generals filing suits against prediction market and crypto exchanges alleging illegal gambling. Now, that's just a smattering of the activity out there. Our focus today is on what this all means from an insurance standpoint. With that said, let's dive right in, starting with David. Now, David, what are you seeing on the claims front, if anything? What kind of policies are you seeing potentially implicated as these platforms and their stakeholders face regulatory scrutiny and litigation?
Sure. Well, at Hub, we work with companies, publicly traded, privately held, financial institutions, fintechs, exchanges, emerging technology companies across North America. And one thing that we've learned repeatedly is that some of the largest claims arise when regulations evolve faster than governance. And prediction markets really fit that description today. What I find most interesting is that prediction markets are creating a very modern version of a very old problem, information asymmetry. And the recent headlines involving government officials and military personnel and unusually well-timed trades all come back to one fundamental question, which is who had access to information that the broader market didn't have. So from an insurance perspective, that's important because the resulting exposure often has very little to do with the actual event contract. Instead, it becomes a governance issue. Were there adequate control? Was there sufficient oversight? Did management understand the risks? Did employees have access to information that could be misused? And once those questions are being asked, D&O insurance really quickly comes into play. The other thing we're watching closely is the potential for parallel proceedings. This is an area where multiple regulators can have an interest in the same conduct. You could have, for example, the CFTC involved and state regulators involved and attorneys general involved and potentially criminal authorities involved, and then civil plaintiffs following behind. And this can create a really very complex claims environment. But perhaps the biggest insurance challenge is that many of the costs begin before there's a traditional claim. So companies are hiring outside counsel and conducting internal investigations and responding to inquiries and engaging with regulators long before a lawsuit is filed or a formal proceeding begins. And that's where policy language really becomes critically important because not all policies respond at the same point in the process. While we're still pretty, I would say, in the early stages from a claims frequency standpoint, I think the industry is already recognizing that the exposure is broader than many people initially assumed. And the real risk isn't whether a prediction market gets the outcome right or wrong. The real risk is what happens when someone asks whether information was used improperly inside of that market.
Thank you, David. And so what type of coverages specifically are you seeing implicated by these type of issues?
I'll start on that question. There may be several different kinds of policies that could come into play or coverages. I mean, D&O is our focus here, but D&O is typically looking at claims that may be made against individuals. And if you're talking about claims that may be made against the company, depending on, again, who is the insured we're referring to, you may be looking at some combined errors and omissions coverage. You may be looking at broader coverage, or you may be looking at investigative coverage. typically when you're looking at public companies and a D&O policy, there needs to be, a securities claim if you're really talking about litigation or a lawsuit. And it's not clear here that these are securities of the company. There's a whole dispute about what these really are. Are they swaps? Are they derivatives? Are they something else? And so the kinds of claims that I think you're likely to see in terms of whether someone acted with improper information or incomplete information or inside information typically going to be made against perhaps individuals for breaches of their duties, or it could be from a governance perspective in terms of breaching overall duties, not having policies in place. And of course, this also, to David's point about when something is triggered, at what point in the process, there you're going to be looking at, is there potential coverage for investigations? Is there potentially coverage if someone may be a target of a government regulatory agency? Is there simply just an inquiry or a thought that there's chatter about something internal and you want to look at that? Is there even a potential, derivative kind of situation or books and records demand? So there could be a number of different issues and policies that might come into play. And I don't know, David, if that's been your experience as well.
It is, and it is. I think it's understanding the interplay of those various policies that could come into place that is so important, especially given where we're at.
Thank you both so much for that information. So whether we're talking about D&O insurance or any other lines, are there any particular exclusions, Caroline, that concern you, and how are those impacting coverage for policyholders?
Yeah, I mean, I think, and David would confirm this, that right now we're not seeing particular exclusions in policies for prediction market claims. At least we haven't seen them, and we hope we never do. So the thing you first want to look at is make sure there's no specific exclusion for what you want to get covered. Then I think the other issues to look at are, just taking a step backwards. Do you have a claim? Do you have an alleged wrongful act here? And then you look at exclusions, which of course are construed very narrowly, and typically the insurer has the burden of proof. So, looking at it from the perspective of a policyholder, for example, the kinds of exclusions that could come into play here are, of course, illegal profit or some sort of fraud. Those typically are drafted very narrowly, and they require some sort, in most instances, of some sort of adjudication of that conduct in some sort of a proceeding. And so if you have some sort of a settlement without an admission, typically you don't have that. There could be some antitrust related activity. We'd like not to see antitrust exclusions in D&O policies, but those would be some of them. The other, it's not really an exclusion, but the definition of loss sometimes within it will exclude certain coverage for maybe fines and penalties. So depending on how this shakes out, government regulatory issues, you have state attorney generals who may have a different perspective. You could see all different aspects of a policy potentially coming into play. David, you may, have a thought on that as well.
Terrific. I would just say that we continue to operate in an environment where policies are getting broader, and I would say that we're seeing them get broader as opposed to conditions being restrictive. And so now is the time to make sure that the policies are properly structured, that the policies are very intentionally designed to work with one another and not against one another, because this market has, I think, afforded a breadth of coverage and a consistency of coverage that we've not seen perhaps ever, but at least in quite some time.
Yeah, and I think the ambiguity about the regulatory aspects is going to continue, and that fluidity can, of course, breed claims as we talked about, but it hopefully will shake out to see this interplay between the CFTC and the state saying no, and the CFTC saying, well, we'd like to, regulate, and of course, then you're seeing some self-regulation in the markets as well, where they may in fact ask who your employers are to know whether or not people trading are using, inside information. All of this, plus, some of the internal risk management policies and procedures having nothing to do with insurance, but just good risk management. I think will also play into the likelihood of risk and exposure.
Thank you both. And David, earlier you touched on the fact that there exists parallel investigations. And Caroline, you just mentioned some of the ambiguities that exist between federal and state regulators. So do you think the risk of parallel investigations, such as a criminal suit from the DOJ or civil suit from the CFTC, Does that significantly add to the insurance complexity? And if so, why is that?
Carolyn, do you want to take that one since the
Sure.
question is more legal in nature?
Yeah. I think it does add to complexity because anytime you do have parallel investigations and you might even be able to trigger different policies, you want to see how everything is going to fit together. I mean, you would like not to have folks coming at you at the same time, and yet there could be different focus, different alleged wrongful acts. You'd be looking at what capacity, for example, you may be having a claim made against you. There could be issues about what policies may trigger coverage at what point in time. Is it an individual? Is it an entity? I think a lot of those, and also what are the potential claims, the allegations, and also what are the potential remedies? What would various parallel investigations or a lawsuit and investigation, what would folks be looking at? Who are the folks making those allegations? In what capacity are you being looked at? And then, of course, which terms and conditions of the policy, definitions of loss, exclusions may come into play. So, anytime you have that interplay, and sometimes we would have seen it traditionally with a securities action and then a derivative, or a DOJ investigation and then a follow on lawsuit by shareholders alleging that your stock dropped because of your investigation. Those kinds of issues may well come into play here. So I think the danger is real, and the same sort of fortitude, foresight, as David said, looking into your policy ahead of time to try to kind of stay one step ahead is always good practice.
Thank you, Caroline. And so building off of that, looking into your policy, I want to pivot to the underwriting side of this. So to David, what are you seeing from carriers on the underwriting front? What type of concerns are coming up as you work to place coverage for clients in this space?
Sure. Well, first of all, because Hub places D&O and E&O and cyber and fintech risks with virtually every major insurer in the marketplace, we get a pretty unique perspective on how carriers are thinking about emerging exposures. And what we're seeing today is really a remarkable level of consistency among underwriters regarding prediction markets. The underwriting conversation today is almost entirely focused on regulation and on governance. Frankly, very few underwriters are spending much time debating whether prediction markets are innovative. Instead, they're trying to understand whether they are governable. And one challenge that we're operating in an environment where the regulatory framework is still evolving. You have federal regulators asserting authority, and you have states asserting authority, and litigation around jurisdiction, and ongoing debates about whether certain products resemble financial instruments or event contracts or something closer to gambling. And underwriters generally dislike uncertainty. So there's a fair amount of uncertainty in this space today. As a result, we're seeing carriers focus heavily on governance. They want to understand who is sitting on the board, who's responsible for compliance, what controls exist around insider information, what the escalation procedures are when concerns arise, and how management's thinking about regulatory developments. One area I think many organizations are still catching up on is employee participation. Most insider trading policies were drafted with traditional securities markets in mind. Very few were written to specifically address prediction markets, and underwriters are increasingly asking whether those policies need to evolve. The organizations that are receiving the most favorable underwriting treatment tend to be the ones behaving like mature financial institutions. So they've invested in compliance and risk management and governance and transparency, and that's where we're seeing the strongest carrier support. But ultimately, the underwriting question is no longer whether prediction markets are innovative. The underwriting question is whether management can demonstrate that they can responsibly govern the risks that come with them.
Yeah, I couldn't agree more. The first place you're going to look is what is the company or the insured organization doing itself with good risk management. Those policies are evolving and they're being very specific because it's no longer about what you did for a deal. It's sort of your individual behavior. So it's also part of sort of corporate values, codes of conduct, but specific policies, as David mentioned. And as a result, when you're looking at terms or conditions or enhancements in connection with the underwriting space, as we said, you certainly want to avoid exclusions, but you also want to look at the investigative coverage that might be available to you. You want to look at the breadth of, things as simple as what's the books and records coverage, what's the coverage if you're not yet in a claim situation. And then there might also be kinds of add-on coverages that might be sublimited that you might not have paid a lot of attention to, but things like crisis coverage or coverage for PR or coverage for reputational expenses, because these kinds of allegations, although they may be small or large, they can have reputational issues for not only the individuals involved, but the board or the company, depending on, again, what's the nature of the allegation, what's the nature of the business of the organization. Is this trading on, defense contracting information or others? You want to be very, very clear. So there would be a lot to look at in that situation.
Thank you, Caroline. That's very helpful. Both Caroline and David, do either of you all have any predictions on where you see claims or investigations going into the next year?
Sure, I'm happy to jump in. If I had to make one prediction about prediction markets, it's that regulatory activity is going to continue expanding faster than regulatory certainty. The growth of these markets, it's really been extraordinary, and regulators are clearly paying attention. What we're seeing in Illinois, for example, you have state officials raising concerns, federal regulators asserting jurisdiction, you have exchanges expanding offerings, you have active litigation over where regulatory authority ultimately resides, and I don't think those questions get resolved in the next 12 months. What I do think we'll see is increased scrutiny around the use of non-public information. So the recent enforcement activities demonstrated how seriously regulators view that issue. Once a few high-profile cases emerge, it tends to drive additional investigations and additional reporting and additional attention from both regulators and plaintiffs' attorneys. I also think we'll see increasing focus on governance. So historically, when new financial or quasi-financial markets develop, the first wave of enforcement focuses on conduct. The second wave often focuses on oversight. So did management understand the risks? And did the board ask the right questions? And were controls appropriate? That's where D&O exposure can be particularly significant. And once regulators begin examining governance, plaintiffs' firms are rarely far behind. That's when you start seeing derivative actions and books and records demands and fiduciary duty allegations and litigation focused on board oversight. So if I were advising boards today, I'd tell them that prediction markets are no longer simply a trading issue or a regulatory issue. They're increasingly becoming a governance issue. And governance issues have a way of finding their way both into the boardroom and the courtroom.
Yeah, I would just add two things. I think the prediction markets will expand, and I think the prediction markets themselves will try to do as much self-regulation as possible to stay out of the crosshairs of the regulators, particularly if there is a continued interest in having them flourish at the sort of top level of government, in a kind of a focused and productive way. The other prediction, and it's probably more something David might be seeing from the carrier side, is I've been reading more and more about prediction markets themselves as a form of insurance or quasi-insurance, where, for example, if you couldn't get coverage for a hurricane policy for your home, and you knew there was a hurricane coming, would you be better off trying to make a bet, in a positive fashion to get some certain coverage if you won that bet, as opposed to trying to get an insurer to cover, let's say, a hurricane? I know that might be an extreme example, but it would be interesting to see if these alternative markets themselves become a form of some sort of self-insurance. And I don't know, David, if that's way far off in the future or even something that's a possibility.
I mean, that's a really interesting concept, and it of course introduces an entirely different layer of potential regulation and oversight. So I can certainly see that being an idea that some explore.
Yeah. Well, it'll continue to be occupying our days, and as you said, what's clearly a prediction is that we can't predict everything that is going to come our way, but that's what makes life challenging and exciting.
Very interesting points, both. And, thank you so much. And so not to keep on playing on this unintended pun of prediction, do any of you have, or either of you have any thoughts on whether we'll see new entrants into the insurance market or, substantial changes in the policies that are available?
I think it's more likely that we'll see evolution as opposed to revolution. We've kind of seen this movie before, right? When cyber first emerged, carriers didn't immediately create an entirely separate ecosystem of insurance products. Instead, existing policies evolve, underwriting evolved, eventually specialized solutions emerged. And I think prediction markets are likely to follow a similar path. So in the near term, I think insurers will continue adapting existing D&O, E&O, cyber crime policies to address these exposures. And we're already seeing greater focus on investigation cover and broader definitions of claims and solutions designed to respond earlier in the life cycle of a regulatory matter. I also think protection for individuals will become increasingly important. So multiple proceedings can occur simultaneously. Directors and officers naturally become focused on ensuring that dedicated protection remains available to them, regardless of what happens at the corporate level. And that's one reason we're seeing increased interest in Side A structures and other forms of executive protection. The broader trend is that prediction markets are moving from being viewed as a niche issue into being viewed as a board-level issue. And once something reaches the boardroom, the insurance market tends to adapt fairly quickly. So if we look forward maybe a little further, 5 years from now, I suspect prediction market exposure will be discussed much in the same way cyber exposure is discussed today, not as a specialty issue affecting a handful of companies, but as a governance and risk management issue that every board and every insurer needs to understand.
Yeah, I couldn't agree more. You need to have good insurance to attract and retain board members. And ultimately, the function of insurance is to allow directors and officers to sleep well at night. And so as this gets more better and there are market leaders, and then there will be evolution of terms and conditions, everything will be, understood better because there'll be better data on the kinds of claims, the kinds of exposures, how to underwrite this, how to address it, and of course, good risk management, which you hope can avoid the exposure and the claim in the first place. So we will check our predictions in a year or two and see how many are accurate.
Thank you both. In this final moment, I would like to give you both an opportunity to just offer one last key takeaway for every listener, and then we can wrap this up.
I'd say be vigilant. Look at your policy terms and conditions now. Look to build the program that you want. And, it all starts at home, which is look internally to make sure your policies and procedures are doing as much as possible to be robust and to exhibit your corporate values.
I would just echo Carolyn's sentiments. We have a saying at Hub that the best claims disputes are the ones that never occur in the first place because we've done the right job putting the policies together. I would say be proactive, not reactive. Engage Carolyn and team. Engage your broker early in the process to make sure that your program will respond in the way that you hope and expect.
Working with knowledgeable brokers is a great team approach that puts our insureds and clients in the very best possible posture. You're never going to avoid a claim. You hope to, but if you get it, you want to make sure you've got your eyes wide open. You know what you've got, and you've done your due diligence. And you're in the best possible situation to minimize it and to seek recovery. Thank you.
Yes, these are, very valuable insights from two very well-respected people in their respective fields. As we can see, this is clearly an evolving area. And I think what today's conversation makes clear is that the legal landscape and the insurance landscape around prediction markets is still taking shape. David and his team at Hub and our colleagues at Reed Smith are well-positioned resources for anyone navigating these issues. Thank you both for your time and insight, and we'll see you on the next episode.
Insured Success is a Reed Smith production. Our producer is Shannon Ryan. To learn more about Reed Smith's Insurance Recovery Group, please contact Insured Success at reedsmith.com. You can find our podcast on podcast streaming platforms, reedsmith.com, and our social media accounts at Reed Smith LLP. This podcast is provided for educational purposes. It does not constitute legal advice and is not intended to establish an attorney-client relationship, nor is it intended to suggest or establish standards of care applicable to particular lawyers in any given situation. Prior results do not guarantee a similar outcome. Any views, opinions, or comments made by any external guest speaker are not to be attributed to Reed Smith LLP or its individual lawyers. All rights reserved.